Is everyone ready for another exciting case from Uncivil Law? Yeah! In today's case, we're going to be covering the Ninth Circuit Court of Appeals. This is Than Oren versus City of Tacoma, coming out of the great state of Washington, city of Seattle. Oh yeah! In this case, we have an interlocutory appeal regarding a person being shot by a police officer. Unjust it was, and whether or not this person can sue for what has happened to them. So we are going to be racking down and covering this. Let's get started! Oh, man. This is the case of Than Oren versus City of Tacoma. In this case, a police officer shot someone, but the circumstances of the shooting are suspect. The shooting is done in circumstances that probably shouldn't have been done. And so we're here to decide whether or not this officer can be held to account under 1983, whether there's qualified immunity, and whether the officer acted improperly. So let's get started with this. Officer Christopher Clark of the Tacoma Police Department shot and severely wounded Than Oren on the night of October the 12th, 2011. Oren sued Clark and the City of Tacoma under 1983, alleging a violation of his Fourth Amendment right to be free from use of excessive force. Clark moved for summary judgment on the basis of qualified immunity. The district court denied the motion, and Clark has taken an interlocutory appeal, and now we affirm. So in this case, the district court denied the qualified immunity. He sought the right to appeal while the trial is ongoing, and the Court of Appeals said, no, there's no qualified immunity here. So another case where a court did not find qualified immunity, more hope is restored. So I'm very happy about that. In an interlocutory appeal challenging the denial of qualified immunity, we must construe the facts in the light most favorable to the plaintiff. Notwithstanding this clear rule, Clark has asked us at several key junctures to credit his version of the facts and to assume a jury would resolve factual disputes in his favor. This we are not permitted to do. So yeah, this is pretty clear. When you're doing this kind of thing, you're viewing the light in the favor of the non-moving party. And here the officer says, I don't want you to do that. I want you to consider things in my favor. I want you to consider these facts that are favorable to me. The Court of Appeals is basically saying you're out of your mind. That's not what we do. That's not what we do. We assume the facts are in the other way, because the issue is, do you win, even if the facts are as they say? We don't know what the facts are yet, but if you don't win with those facts, then we need to know that. So no, we are not going to take you up on your suggestion. Nice try. You could go the route of legal eagle and bend the law into pretzels to justify things that have no actual basis in law. Tempting. No. The hyper bubbly personality was more authentic than doing that. I don't want to bend the law into pretzels. And, I'm trying to be an educator, and I don't want to educate you on untruths. The Don totally had it coming. Captain Marvel was completely innocent, lol. Unless Oren's version of events is blatantly contradicted by the record so that no reasonable jury could believe it, we must assume the jury could find Oren's account of what happened credible, even if it conflicts with Clark's account. Here, nothing in the record blatantly contradicts Oren's account of the events in question. The narrative that follows is thus resolving all disputes in their favor. So yeah, there is an exception to assuming the facts are in light of not non-moving party. Basically, if what you're saying is ridiculous, we're not going to take that because there's just no way. So if it's ridiculous, we'll ignore it. If there's lots of other evidence that completely contradicts it, we'll probably ignore it. But otherwise, we're going to take the light most favorable to you. So unless it's completely contraindicated, completely ridiculous, we'll assume you're right. And so now they're going to recite the facts as the person who was shot would tell them. So bear in mind, these are not the facts of what happened. This is one version, the most favorable version of the facts that happened. So at trial, the actual facts have to still be resolved. But we're going to listen to the most favorable version of the facts from the person who was shot. So that's good start there. Yeah, assault with the deadly weapon, I think. I sort of alluded to it as well in my Captain Marvel review, where I said, I didn't say assault with the deadly weapon, but I did say it when I was talking about whether or not it was lethal force. Because I said, normally someone gripping a hand is non-lethal force, but the superhero with superpowers, and therefore is that lethal force? So that's something we'd have to analyze. So I did kind of get to it eventually on the back end. But yeah, I think that is a relevant factor. At around 8:30 p.m., Orrin was driving his wife's Mitsubishi Moranto on city streets when he noticed a police car with its lights activated attempted pulling him over. The officer sought to stop him because he was driving without his headlights on. Orrin was driving with a suspended license at the time, and he had just smoked crack cocaine. Not super smart. Rather than pull over, he decided to return home to the apartment complex where he lived with his wife, as she knew she needed the car for work. So the idea here is, okay, I'm about to be pulled over, I'm about to be arrested, they're going to tow the car. But if it's already at my home, they don't need to tow the car because it's already in a place where it can be left. So he's trying to be courteous to his wife by bringing the car back home so that she won't be without the car and have to get it out of the tow yard. Well, at least that's kind of a nice gesture, okay. As he made his way home, Orrin traveled 25 to 35 miles an hour and stopped at traffic lights and stop signs. It took Orrin roughly 15 minutes to drive home. Along the way, additional officers joined this slow speed pursuit. That's funny. Including Clark and his partner, Donald Rose, who were driving a Tacoma Police Department sports utility vehicle. At one point, in an effort to get him to stop, several police units attempted unsuccessfully to box him in. At another point, officers drove in front of his vehicle to block his path, but Orrin drove onto the curb and down a portion of the closed roadway to avoid them. I understand you're coming from a good place, but I cannot recommend this course of action. You are now actively invading. You're engaging in obstruction of justice. You're actively invading, and police never know what's going to happen in chases. They can go all kinds of places, all kinds of things. So I would really not recommend this. I would recommend pulling over as soon as practical. If you are like on a highway that's like nowhere, if you can pull over in a service station, so you're like at least near somebody, so there's lights and everything, I think that's okay. But try to pull over as soon as practical. If you're in the middle of nowhere, try to pull over where there's other people so they can see, in case it's not a real policeman or something like that. But otherwise, this is not to be recommended. Later in the pursuit, officers put down spike strips, which Orrin managed to circumvent by swerving away from the officers and into the oncoming lane of traffic. No oncoming vehicles were traveling towards Orrin at the time. Again, this is reckless driving now, right? Driving into the other lane of traffic is reckless. You're fortunate that there are no other cars there, but I'm not sure that actually matters. You're evading this. You're in an active invasion. You're trying to avoid being boxed in. You're driving onto curbs. You're driving in the other lane of traffic. The police are taking some note of this. This is not good. I do not recommend this course of action. Pull over soon. Put on your interior lights, even if it's the middle of the day. I recommend putting on your interior lights so they can see clearly, and keep your hands on the keep your hands on the wheel, and go from there. As the pursuit progressed, officers correctly predicted that Orrin might be returning home, since by then they had determined the address to which his vehicle was registered. Clark knew that in Orrin's apartment complex, he had a long outdoor parking lot with two entrances, one at the north and one at the south. When Clark saw Orrin headed towards the south entrance, he drove towards the north end of the complex and entered there, which is very reasonable. Clark positioned his SUV across a narrow point of the single-access lane that ran the length of the parking lot in an effort to prevent him from exiting the complex at north end, which, you can't object to that. Orrin pulled into the south entrance with a caravan of police officers behind him. He proceeded slowly down the access lane towards the north end of the complex. When he approached the Clark's SUV and saw that it was blocking his path, he paused and came to a brief stop. The diagram below depicts the scene of the events that transpired next. Clark was standing on the grassy area next to the left as Orrin approached. He had his gun drawn with the barrel pointed to the ground and repeatedly yelled at Orrin to stop. Clark had no reason to believe that Orrin had a firearm. In fact, he did not. Orrin saw Clark and heard his commands but ignored him. Again, this is a little bit on the driver here at a bare minimum, right? We don't know what you're doing. We don't know why. We know you're evading us. And so, we're escalating our force. We're escalating a force. Our initial force was to just have sirens on. And now, because you came to the car and you saw the car and now you're reversing, we have no idea what your intentions are. We don't know what's happening. And so now the police officers are starting to point guns at you. They have escalated force. And at least at this point, I don't think they're escalating unreasonably because they don't know what's happening. So, don't do this is my recommendation. After briefly stopping in front of the Clark's SUV, Orrin drove away from Clark, where he's standing, and attempted to navigate through a narrow opening between the passenger side of Clark's SUV and a nearby car. So he's now trying to drive between two cars, including one of which is the officer's car. Good. To do so, Orrin had to drive upon the curve onto a small patch of grass between the two vehicles and then turn his vehicle to the right. Given the tightness of the space, Orrin was driving very slowly as he attempted this maneuver. Okay. He estimated his speed at 5 miles per hour, as did officers at the scene. When Orrin began maneuvering around Clark's SUV, another officer, Stephen Butts, backed his patrol vehicle into Orrin's line of traffic to cut off any path of escape through the complex interest. Right? This is like what you would be expecting. We're trying to box you in, prevent your escape, all that good stuff. Yeah. That caused Orrin to turn his vehicle more sharply to the right to avoid hitting the vehicle. So he's continuing to try to escape. This is not good practice. As Orrin moved past Clark's SUV, the panel near the passenger side wheel of the vehicle clipped the passenger rear quarter of the vehicle. So now we have car-on-car contact. Officer Rose, who remained inside the SUV and felt the impact, described it as a glancing blow. The left front corner of Orrin's vehicle also struck the right front corner of Officer Butt's vehicle. So now he's striking two cop cars. Yeah. Just after Orrin moved his vehicle past Clark's SUV, Orrin saw Clark run towards his vehicle on the passenger side and begin firing at him. Okay, at this point, this is the point where we're thinking excess force, right? Is the shooting of the guy. This is a point of differentiation. But, it's a little bit on you. It's a little bit on you. You had many opportunities. You're now running into cop cars. You could have stopped by a side road. You could have stopped in the apartment complex. You could have stopped when you came up to the vehicle. You could have stopped when they tried to block you in. You turned around. You turned into a sidewalk. You turned onto the other side of the road. You're now scraping past two cop cars. Did the police overreact by shooting you? Yes. But man, it's a little bit on you. Okay? So let's just keep that in mind. The first round entered through the front passenger side. The second and third rounds entered through the rear passenger side window. One of these rounds struck Orrin in the spine, which caused his body to go numb. He slumped into the passenger seat and engine of his vehicle revved loudly as his foot floored the accelerator. Clark ran behind the vehicle as it sped away, firing 7 more rounds through the rear windshield. Clark disputes this account of the shooting. So now we're going to get because remember, we haven't established the facts. We're just saying what this person said. The person who was shot said. So now we're going to discuss a little bit about what Clark said. So what his version of the events look like. Clark disputes this account. His account differs from Orrin in 2 key respects: the manner in which Orrin maneuvered his vehicle and where Clark was standing when it occurred. According to Clark, as soon as he saw Orrin drive up on the curb onto the patch of grass, he ran from where he had been standing and took up a position behind the rear bumper near the passenger side of the SUV, as depicted by the faint blue figure in the diagram we saw earlier. Clark contends that as Orrin maneuvered between the cars, Orrin's wheel charged sharply to the right, which placed Clark in the path of the vehicle. At the same time, Clark said, Orrin stepped on the gas and propelled the vehicle towards him under hard acceleration, causing him to fear that he'd be run over or pinned between the vehicles. According to Clark, he placed his left hand on the side of Orrin's vehicle to brace for the impact while simultaneously raising his right arm above his shoulder. He then fired 1 or 2 rounds downward into the vehicle as it passed. Clark asserts that he chased after Orrin's vehicle and continued to fire at it from behind because he feared for the safety of Officer Rose, who he thought might be standing in the area where the vehicle is headed. So, that seems plausible. It could have been that too, right? We're assuming that the victim is correct, but this story seems plausible as well. So that's something for a jury to figure out, but we're here on a qualified immunity issue. Whether or not you can qualified immunity, not the ultimate issue who did what. After Clark stopped firing, Orrin's vehicle continued forward and hit several parked cars before crashing into a chain link fence, which stopped the vehicle's forward progress. Officers took Orrin into custody and summoned medical help. In all, 3 of 10 rounds fired by Clark struck Orrin. The bullet that lodged in his spine has left him paralyzed from the waist down. I don't know that you can necessarily conclude that the first bolt that hit him was the one that paralyzed his spine, because that's the way the court said it, right? It would make sense if it was, but it would also make sense if it wasn't, right? He's paralyzed, so his foot goes to the floor and he skids off. That makes sense. It also makes sense that the first bullet struck him somewhere else. He floors it because he's been struck, and some later bullet struck him. So I don't know you can conclude the first bullet is the one that caused the paralysis. So I think the Court of Appeals kind of made a slight mistake there. Clark prosecutors charged Orrin with using his vehicle to assault Clark and attempting to elude a pursuing police vehicle. We're now going to charge the guy, because of course we are. You know, you've done some potentially bad things here, my friend. The jury acquitted Orrin of the assault charge. It also acquitted him of the eluding charge, convicting him instead of the lesser included offense of failure to obey a law enforcement officer. Orrin was ordered to pay a fine of $250. Well, I don't know about that, man. I mean, for me, I feel like the eluding charge is pretty good. But, you know, the jury did what the jury did. They felt like it was just refusal to obey a police officer and levied a $250 fine. If I had to bet, probably out of sympathy because of the harm he had occurred. So the jury showed him some grace because of the injury he had had, if I had to guess. But, so they just said it's $250 fine. Fine. Yeah, and someone pointed out the ballistics would confirm the story. I don't know that we have any ballistics at this point, because I don't think we've gone that far into the trial. We're still on a qualified immunity issue. So I don't think we've gone as far as ballistics or being able to determine which gun shot who, when, and which bullet caused the paralysis. So I don't think we know that. It may be determinable from ballistics at trial. So yeah, that may be possible. But you know, we don't know that yet. When an officer asserts qualified immunity as a defense, our analysis proceeds in two steps. We first ask whether the facts taken in the light most favorable to the plaintiff show that the officer's conduct violated a constitutional right. If so, we then ask whether the right in question was clearly established at the time of the officer's actions, such that any reasonable, well-trained officer would have known the conduct was unlawful. So now we have to get into the issue as to whether or not qualified immunity is appropriate under these circumstances, given this such situation, given the disputed facts, given the law that we have. So what is the issue on qualified immunity? At the first step, a reasonable jury could conclude that Clark violated Orrin's Fourth Amendment right to be free from the excessive use of force. Determining whether an officer's use of force violates the Fourth Amendment requires balancing the nature and quality of the intrusion on the individual's Fourth Amendment interest against the importance of the government interest alleged to justify the intrusion. So it's a balancing test. How important is your interest? How important is the government's interest? Fair enough. That inquiry generally involves an assessment of factors such as the severity of crime at issue, whether the suspect poses an immediate threat to the safety of officers or others, and whether he's actively resisting arrest or attempting to evade arrest by flight, which I would indicate is probably here. The Supreme Court has also crafted a more definitive rule. An officer may use deadly force to apprehend a fleeing suspect only if the officer has probable cause to believe the suspect poses a threat of serious physical harm either to the officer or others. So yeah, it used to be the case that you could use lethal force for any fleeing felon, but the Supreme Court constrained that. You can now only use lethal force if they're posing a threat to yourself or others. So like every cop show ever, where they say like, if you run, I'm going to shoot you. We don't know whether or not they mean it, but if they do mean it, that would be illegal. Because unless he's posing an imminent threat or something, or like, you know, he's on his way to perform a threat. Like if you know that he's running in the direction of, you know, his girlfriend's apartment and that would pose a threat, then short of that, you can't shoot a guy just because he's fleeing from you. You need to have some, you have to have some basis for saying it's a threat. You can't use a shot to do an arrest, basically, is the short version. By the way, this is completely off topic. But did anyone see that video of that off-duty woman Brazilian police officer who shot that guy? That was a really cool video. Anyone who's not seen it, so there's a guy who's approaching a group of women. It looks like exclusively a group of women, but whatever. Approaching a group of women who appear to be standing by the side of the road for the purpose of a school bus stop, is what appears to be going on. And this guy is approaching them with a gun. It is outstretched and pointed at them, and apparently is demanding money. And one of these women happens to be an off-duty Brazilian police officer. So she pulls her gun from her purse and shoots the guy in the chest, and then he dies. Insta karma. The whole thing took less than 5 seconds. The whole thing was under 5 seconds. From the time the guy started approaching to the time he shot in the road, under 5 seconds, and we're done. It was awesome. I like Insta karma. Insta karma rocks. Yeah, there's a million videos like this, but this happened to be recent. So yeah, I know there's lots of videos, but I was just pointing out there's a recent one on this. And personally, I'll watch all a million of them because it brings me joy. The key question is whether Clark had an objectively reasonable basis for believing that Orrin posed a threat of serious physical harm either to Clark himself or to others. Taking the facts in the light most favorable to Orrin and giving due deference to Clark's assessment of the danger presented by the situations he confronted, we conclude the answer is no. So again, if we assume the facts as the person who was shot says them, in that situation, we say that this is not qualified immunity. But you still have to go back and prove it, so yeah. Clark does not dispute that an officer who fires in the side or rear of a vehicle moving away from him lacks an objectively reasonable standard for claiming he did so out of fear. So if you're not on the path, you wouldn't have fear. That makes sense. He instead urges us to analyze the lawfulness of his actions under his version of the events, which is no, in which he stood in the path of the vehicle as it accelerated towards him, causing him to fear for his life. If that were true, that would be good cause. But we're not doing that right now. We're assuming things are the other way around. We're putting things in the light most favorable to the guy who shot. You'll have your turn later. As noted in the outset, we cannot analyze the case through that lens because Clark's version of events conflicts with facts construed in the light most favorable to Orrin. Most fundamentally, Orrin's testimony provides an account of the shooting in which Clark was never at risk of being struck. Although Orrin's testimony alone would be sufficient to create a material dispute at this point, Officer Butt's testimony provides additional support for Orrin's version. Officer Butts testified that he saw Clark standing behind the rear bumper of the SUV only after Clark fired the first round of shots, and that he did not see Clark make any physical contact with Orrin's vehicle. Officer Butts also testified that he heard Orrin's engine rev and saw the vehicle accelerate after the first shots were fired, not before, as Clark maintains. A reasonable jury could find Officer Butts' testimony significant because his vehicle was parked facing the rear passenger side of the SUV, giving him an up-close vantage point to which to see and hear what transpired. So the officers are apparently not doing the thin blue wall thing today, and they are saying, well, one officer is contradicting him, but still, it's an issue for trial. So go back to trial, everyone testified, the jury has to sort it out. That's what juries do. License to own a gun is now licensed to carry. I did not see that changed in Puerto Rico laws. That is amazing, because Puerto Rico has had very strict laws, so we have 2 cases after this, as a matter of fact. We're on 3 hours and 21 minutes, and we have 2 cases left. So, we are here. We are here until we're done. Again, why I didn't want to start the stream late. But if you have to bounce out, that's fine. Even if a jury found that Clark was standing behind the rear bumper of the SUV as he claims, it still could conclude that Clark lacked an objectively reasonable basis to fear for his own safety. As Orrin's vehicle approached, Clark concedes that he was not initially in the vehicle path of travel. He contends that his safety was imperiled when Orrin turned his wheels more sharply to the right to squeeze between the vehicles. At that point, Orrin's vehicle was moving at just 5 miles per hour. Clark could therefore have avoided any risk of being struck by simply taking a step back, a common-sense conclusion confirmed by Clark's own admission that he was able to step backwards and get out of the path of the vehicle. In similar circumstances, we've held a reasonable jury could find an officer standing near a slow-motion vehicle would not have perceived himself to be in danger because he could have avoided injury by simply stepping to the side. The remaining question is whether Clark had an objectively reasonable basis for believing that Orrin posed a threat of serious physical harm to others. On this point, in both the district court and before our court, Clark has argued only that Orrin posed a threat to his partner, Officer Rose. As noted earlier, Clark mistakenly, but reasonably believed, Officer Rose had exited the SUV and may have been standing in the area where Orrin's vehicle was headed. In fact, Officer Rose remained inside the SUV until after the shooting. Clark claims that he feared for the safety of Officer Rose because Orrin had just attempted to run Officer Clark over and thus might have been inclined to Officer Rose as well. But if a jury rejects Clark's account of the shooting and concludes Clark was never at risk of being struck, nothing else Orrin has done suggested he posed a threat to the safety of Officer Rose. So here pointing out the truth that the jury, when they're considering things, can consider your testimony in whole or part or none, and that they concluded that you're lying about one part, you might be lying about other parts. So it's up to the jury. Yeah, if the jury found you're exaggerating the truth about your own danger, they might conclude you're exaggerating the danger about this to your partner as well. So yeah, that's the jury's decision. And also a good idea why not to lie, because if the jury catches you in a lie, now they're in the position of, well, how much of this other stuff do we want to trust? How much of it's reliable? Good times had by all. Clark has not argued that his use of deadly force was justified on the theory that permitting Orrin to escape could have posed a threat to the safety of the general public, nor is there any basis in the record for making such an argument. A fleeing suspect's escape can pose a threat to the public when police have probable cause to believe the suspect has committed a violent crime, but neither of the offenses for which Orrin was wanted involved any sort of violence. A reasonable jury could conclude that Oren did not engage in any such conduct here, and that Clark, therefore, had no basis for believing that Oren would pose a threat of serious physical harm to the general public if it permitted him to escape. In short, if Clark decides to pursue this line of argument at trial, the jury will have to determine whether Oren engaged in conduct that demonstrated a willingness either to injure officers or to persist in extremely reckless behavior that threatened the lives of all those around. So next, the court has to get into whether or not this was previously established for 1983 purposes, whether he was on notice about that. To the extent Clark seeks to justify his use of deadly force based on a threat to his own safety, existing precedent declares his conduct unconstitutional in circumstances indistinguishable from those present here. By the time of the shooting in October 2011, at least 7 circuits have held that an officer lacks an objectively reasonable basis for believing his own safety is at risk when firing into the side or rear of a vehicle moving away from him. As discussed above, taking the facts in light most favorable to Oren, a reasonable jury could conclude both that Clark was never in the path of Oren's vehicle and that he fired through the passenger side windows and rear vehicle as it was moving away from him. On that score, existing precedent squarely governs the specific facts at issue. Clark is not entitled to qualified immunity based on his claim of fear of the safety of others, in that case of Officer Rose. The objectively reasonableness of Clark's fear for the safety is again dependent on a jury's acceptance of his account. According to Clark, Oren ran over him after turning the vehicle, but a reasonable jury could conclude, contrary to the events of Clark, that he was never at risk of being struck, and if the jury disbelieves Clark on that, it could disbelieve him and conclude nothing else he has to say is reliable. In the end, this is not a case in which the legality of the officer's conduct falls between a hazy border between excessive and acceptable force. When the facts are viewed in light most favorable to Oren, as they must be at this point, Clark had fair and clear warning of what the Constitution requires. What Clark most forcefully contests is whether he has an alternative account of shooting that could be accepted as true. Factual disputes of that order must be resolved by a jury, not by a court adjudicating summary judgment. Therefore, we affirm. Yeah, and don't forget that 20,000 of those 30,000 deaths are from suicide, so that's an important number to also bear in mind. So, I think it's relevant when we're talking about the gun issue that, 2/3 of those are suicides. So that is the end of the case of the United States Court of Appeals for the Ninth Circuit from Washington State in the case of Than Oren versus the city of Tacoma. In this case, we learned that Oren went on a police chase and was ultimately shot. There is a different accounting of events. In Oren's description, the police did not have justice to shoot him. In the police's version, they did have justice. But the issue here is qualified immunity, and we take the light most favorable to the non-moving party, in this case, the person who was shot. So given his description of events, there wouldn't be no qualified immunity, and we'd have to be responsible. So we have to go back to trial and determine what the facts are. This is a jury question: who is telling the truth, who has the best issue of what happened, and so it has to be resolved at that level, and we will see what happens next. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.